Edward for Lazar, Washington.
All right, folks, buckle up. We've got plea deals, bond negotiations, and even a surprise stalker subplot. This is one of those hearings where the backstory is just as messy as the charges.
State your name, please.
Hello, my name is Larzell Washington. Larzell O'Neill Washington, sir.
Thank you.
Your Honor, I have a green sheet filled out there. I'm asking for an adjournment to continue negotiations. There's been an offer to a misdemeanor in this case. He does need to get screened for the 14B recovery court. It's not a contingent that he gets in, but he needs to get screened.
And that's part of the arrangement or the plea deal.
That's correct.
Part of that.
We've both signed that. We would need your signature in order to record that.
Do you have an estimate as to how long they're taking at this point to do the?
I'd ask for 2 weeks.
Quick note, when you hear bond continues, that means the judge is keeping the same bail amount and conditions. In other words, no early Christmas gift for the defendant today.
Probable cause conference in this case will be adjourned to 2025, 9 a.m. bond continues.
And I would actually ask to address bond at this time.
Go ahead.
Mr. Washington was originally arraigned on March 27th. They set up probable cause conference for March 27th. He did not remember what the date was. He then did have an interaction with the police where they weren't actually looking for him, and they found out his name and located a warrant, so he was picked up. He was arraigned in this.
What kind of interaction with the?
He wants to address that.
This young lady I knew was being basically stalked.
That what?
She was being stalked and she was panicking. So I walked past her and told her, you know, leave her alone, leave him alone before he hurt her. And so they kept asking me the guy's name. You know, I couldn't, you know, tell him his name. Then, you know, the guy inquired on who I was. I normally sell ground cover news, but it wasn't no problems on my end. And I'm, you know, I'm happy. I didn't know the courthouse was this close. I would have been down here too.
So I do have a contact number for him.
Question for you. Do you think telling your side of the story in court like this actually helps? Or does it just give the prosecution more to work with? Drop your thoughts in the comments.
He indicates that he would not object to any community corrections order.
I'm not going to change the bond. We'll see bills and then I'll take a look at the whole package.
Okay.
All right.
Thank you.
So motion for objections denied, bond will continue.
Pete, come on, man.
Want me to do something different? Because you don't want it. Don't walk out of here like that.
Yes, sir.
Thank you, Your Honor.
Good morning, Your Honor. Brandon Bird on behalf of Sean Oldham, PA 3734. Mr. Oldham, can you please state your full name for the record?
Sean Martell Oldham.
Thank you.
You up?
Yes, sir.
Respectfully, Your Honor, I did get it. I know I got a. I know you.
People have their witnesses available the 13th.
We'll try our best, Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. before me. Bond will continue.
To address bond, Your Honor.
Go ahead.
Client, 40-year-old, 6 kids. 2 of them are grown. He helps raise them all. Lifelong resident, Your Honor. He is employed. He's trying to get back to being able to support his kids in this matter. I do understand this is a domestic violence third offense notice. My client indicates to me that he came in contact with the police because he actually went to the police station to file a report on the complaining witness. The complaining witness showed up to his job, and because the complaining witness showed up to his job, that was counted as contact. As soon as that matter happened, my client, out of his own volition, called his probation agent, called his probation agent to see what he should do. Probation agent told him, go to the police department and put in a report. When he put in that report, he turned around and got arrested in this matter. I do believe he was arraigned on his probation violation, in which he indicates to me that he received a $100 bond in that matter. I'm not definite, but I'm pretty sure the court probably knew about this case when they gave him that $100 bond, because this case stems back from March 28th, Your Honor. Respectfully, my client understands no contact with the complaining witness. At this point, he doesn't want any contact with the complaining witness. He didn't want contact with the complaining witness when he came into contact with her at his job. So respectfully, we're just going to ask for a personal bond. My client doesn't mind the tether if we have to do a tether. This is a relationship.
Whoa, $50,000 cash bond. That's not pocket change. And with a history of prior domestic violence charges, the prosecution's basically saying, we're not gambling on this one.
Where both of them need to stay apart from each other. He was doing his due diligence to stay apart from her. And just respectfully, Your Honor, we're requesting a lower bond, hopefully a personal bond, so he can at least get back to work and take care of his children, Your Honor.
Response.
Your Honor, I would strongly object to any change in his bond. I believe it's set at 50,000 cash surety at the moment. Mr. Odom has a lengthy history of dismissed DVs as well as DV conviction from just this year with the same victim for a DV second, which was pled down. He's currently on probation for that and violated his probation with getting this new case. In the report for his bond violation, the victim informed officers that she let him borrow her car because he had nowhere to stay. She asked for the car back. He came back to her house and was yelling at her. And she also stated that he pulled out a knife while he was there. So I have great concerns that he can't follow court orders and would keep getting in contact with the victim.
Obviously, the tether stops a knife. That's sarcasm from the judge, folks. Translation. Electronic monitoring might track you, but it won't protect anyone if you show up with bad intentions.
And wouldn't be able to stay away given that he's already on probation for domestic violence with the same victim.
Yeah, and there's ways to mitigate these circumstances, and the way we can mitigate that is with a tether. Is with a tether. Obviously, the
I don't know that a tether stops a knife, but go ahead.
I'm not saying the tether stops a knife, but at least it'll let you know. At least it'll let you know if he's around the complaining witness, and if he was there, and they could come get him right away.
And Your Honor, I did also want to make clear that previous case that was pled down was a previous FA with the same victim. And then in the underlying case of this case with the same victim, he grabbed her by her hair, pulled her into the living room, a fight ensued, and in the process of that, he hit her child in the face, he punched him, leaving him with a black eye. That's the underlying case that was out on file for. So I have great concerns.
And that he's still innocent unless proven guilty beyond a reasonable doubt to, Your Honor.
Motion for bond reduction denied. Bond will continue.
Thank you for hearing me out, Your Honor.
Court does call the case People versus Theophilus Smith.
Andrew Childers appearing on behalf of the people, Your Honor.
Kelsey Vergils with and on behalf of Theophilus Smith, who appears via Zoom. Mr. Smith, please state your name.
My name is Theophilus Smith, Judge Simpson, and I would like to speak today because what's going on in this jail, Judge Simpson, is a prime example of the paper I wrote when I was.
And here's where things take a turn. Mental competency questions enter the chat. This next part. It's a raw, unfiltered plea from a defendant who says his safety is on the line.
At Michigan State University.
Mr. Smith, I would advise you to not speak at this time. Mr. Smith, just let us handle the matter, please. Your Honor, I provided the court with an order. Mr. Smith met with the forensic center who deemed him incompetent but restorable. We have no objection to those findings and asked the court to give him time to be potentially restored.
Any additional information from the people?
No, Your Honor. The people would stipulate to the report as well. Thank you.
All right. Court, upon reviewing the report, would find at this time he's incompetent to stand trial. but likely to obtain competence, provided the course of treatment. Given that, the court will sign an order to that effect. And I've signed that order. I will adjourn this for a competency review to 90.
Judge Simpson.
I'll set a competency review for July 30th, July 31st, 2025, 9 a.m.
Okay, can I speak with you now, Judge Simpson?
Mr.
Can
Smith,
you what?
I need to speak with you because I need to ask you some questions. I know they deem me incompetent, but Judge Simpson, my safety is at threat in this jail. I'm strong. Judge Simpson, they've been breaking me down mentally, physically. They've been stripping me of my dignity. The COs and the inmates are in cahoots.
Okay, Mr. Smith, Mr. Smith,
I need Judge.
okay, just listen. Hey,
Judge Simpson.
hold on.
Yes.
I've given you another date. You're gonna get a chance to come back and talk, okay?
Yeah, because it feel
But
like.
right now, you're gonna have to talk to some other folks.
I'm out today, you said, Judge Simpson?
What'd you say?
Judge Simpson, excuse me, sir? Yeah, I'm strong. I'm out today.
He's asking what's out there.
No, not today.
Mr. Smith, you're gonna,
Judge Simpson, what this jail is doing, they trying to attack Judge Simpson. Believe what I'm saying.
Mr. Smith, you're gonna get some mental health treatment. Please call the public defender's office.
All right, Mr. Smith, contact your attorneys and we'll see what we can do, okay?
How long do I'm not even suicidal, Judge Simpson. They got me in.
All right, Mr. Smith, I'm done.